So again, even if you've worked for 12 months, you have to meet this 1,250-hour requirement. Here, this is measured backwards in a consecutive 12-month period. So this is not cumulative during employment. This is, have you worked enough recently to now be eligible to take time off from work? Only hours actually worked satisfy this 1,250-hour requirement. So time taken either on previous forms of FMLA leave or for vacation or sick leave that the company allows, what have you, those do not meet the 1,250-hour requirement. This is a requirement that says not just how long have you been working for the company, but have you in essence contributed enough in the past year of actual work to the company that the company should now be expected to let you take time off. Certainly, if someone just was perpetually on FMLA leave, it could make it difficult eventually to maintain this 1,250-hour requirement. So this can result in individuals not being able to take FMLA as much as the law theoretically allows, which by default in most cases, as we'll get to, is 12 weeks per year. But depending on how many hours you regularly work, if you were to miss some or all of that 12 weeks for FMLA leave in 1 year, then you may not be able to take FMLA in the next year, at least depending on how that next year is defined, which again, we will get back to. The main caveat on this is this ideally should be pretty easy to track for hourly employees who have to record their time, and that determines their compensation, where ideally your payroll system is separating out hours worked from other hours. The regulations from the Department of Labor emphasize that if there's not an accurate record keeping of hours actually worked for an individual employee, then the employer basically would have to prove that they hadn't worked the 1,250 hours in the past year to be able to deny FMLA leave on that basis. So where this is most likely to come into play is for exempt employees. Exempt and non-exempt employees with respect to minimum wage and overtime are equally eligible for the FMLA. The only exception to eligibility is for key employees, which we will address briefly later in this webinar. But for an exempt employee, many companies will just assume they're working 40 hours in a week, but technically, if that math doesn't get them to 1,250 hours and they can argue that they actually work 60 hours in a week, for example, such that they did have 1,250 hours, then it would again be the employer's burden to somehow prove out the math that the number is not met. There are some companies that go to the step of tracking time worked for exempt employees in part because of this FMLA requirement. That is not an obligation under the FMLA. The FMLA itself does not require you to track anyone's hours. But again, if you can't prove that they worked less than 1,250 hours, it would be at your risk to not allow the FMLA leave.